Welcome to the McAfee Taft webinar series. The topic for this webinar, transgender, sexual orientation, and stereotyping issues in the workplace. While Title VII of the Civil Rights Act of 1964 does not specifically prohibit employment discrimination based on one's sexual orientation, gender identity, or gender expression, there is a growing trend, particularly at the federal level, but also in some states, to expand civil rights protections to gay and transgender workers. The U.S. Supreme Court has even weighed in on the issue of discrimination against employees who don't meet traditional gender stereotypes, such as the woman perceived to be too masculine or a man considered too feminine. In this presentation, we will be discussing the evolution of federal and state laws prohibiting sex and gender discrimination, reviewing the important court cases that set the stage for the current shifts in position and policy, and discussing employer best practices for maintaining a welcoming workplace while avoiding discrimination litigation. Our presenters are McAfee Taft labor and employment attorneys Roberta Fields and Charlie Plumb. They both represent employers in all phases of employment law and labor relations, and are frequent speakers and authors on labor and employment issues before state, regional, and national audiences. So, with those introductions, I now turn it over to you, Roberta.
Today, we hope to give good practical advice on this topic, but first, let's talk about why we are even talking about this subject. There has been more attention to sexuality issues in the workplace lately. We think maybe for the following reasons. The Supreme Court legalized same-sex marriage. Bruce Jenner became Caitlyn Jenner, which was widely covered by the media. There's a younger workforce who views these issues perhaps differently than prior generations. And finally, although there's no federal law that protects transgender, sexual orientation, or covers sexual stereotyping issues, there are state and municipal employment laws that have been enacted recently that do protect transgender and do cover sexual stereotyping issues.
And Roberta, one of the things I'm seeing why the issue of sexuality in the workplace is getting more and more traction or becoming more and more an issue with employees is we have some points of friction or some tension between employee groups. As you pointed out, it's not unusual in this particular context that younger members of the workforce may feel quite differently from older members of the workforce when it comes to working with a transgender employee or addressing a sexual orientation issue in the workplace. Another point of friction or tension is we may find an employment environment in which you have a group of employees, because of their very sincere religious beliefs, feel very differently about transgender employees or sexual orientation issues than their coworkers. So I guess the point I'm making is seems to be bubbling to the surface a lot of times because we have a changing and diverse workforce.
I think that's true. And of course, Title VII has some religious exemptions, but that's beyond the scope of what we're going to discuss today. Another reason this is such an issue is in 2012, the EEOC formally took the position in their strategic enforcement plan that they would find a way to cover lesbian, gay, bisexual, and transgender employee issues. They were determined, even though Title VII did not offer protection for these categories, to find a way to offer protection. And we'll talk later about how in fact, they did that, relying on some old Supreme Court cases. Well, at McAfee Taft, in the last year or so, we have seen an increase in questions along these lines. Wouldn't you agree, Charlie?
Absolutely. It's really exploded, I think, in the last 6 to 12 months.
Now, oftentimes the questions come to us from employers because they receive complaints by coworkers. We'll discuss that a bit later, but for whatever reason, we are seeing more of these issues. So as an employer, how might the issue of sexual stereotyping or sexuality in the workplace, how might this reach your desk? And I think that probably the most, if our research is any indication, probably the most common way that this issue reaches the employer's ear is a complaint by a coworker. There's an individual who intends to present as a different gender than they are biologically, and so they are asking to use the restroom consistent with their new gender identity. And oftentimes that is upsetting to coworkers. And so I think that's probably the most common way this issue comes up.
Yeah, and another example, and I agree with you entirely that that's probably the number one way it comes to an HR professional's attention. You may have an employee who said, "I don't want to work with a gay coworker. I'm not comfortable working with a gay coworker, or I'm not comfortable and won't work with a transgender employee that's transitioning. I'm just not willing." So that may be how it ends up on your desk as the HR director.
And then you have a situation that you must deal with. Another way this comes up is, the employee actually comes to HR or to management and says, "I may be biologically one gender, but, inside my gender identity is of the opposite gender. And so I intend to transition. So I intend to begin dressing as the gender I identify with, so male to female, female to male, and help me do that." And so at that point, as a manager or an HR professional, it would be your role to help the company come up with a plan to deal with that. And as we'll talk about later, it's ideal that you have a company viewpoint or stance or game plan before this happens. But that's another, I think, common way the issue gets raised to companies. Of course, there are the medical procedures. Someone could be absent if they're receiving hormonal treatments or if they're having some sort of medical procedure, and that issue may come to your level by the employee asking for time off, or it may come to you by a supervisor complaining about the frequent absences of an employee. Either way, this issue reaches your desk and you must deal with it. There can be insurance coverage questions. An employee approaches the benefits department indicating their plan to take hormone treatments or to have surgery, and they're asking about coverage. And so that's another way that this issue could reach your desk.
Sometimes it also comes up in the context of a complaint of unfair or harassing treatment. The employee who is dealing with the sexual orientation or sexual stereotyping issue or their own transgender status may tell you, I'm being mistreated, or I'm being harassed by coworkers, or I'm not being given fair and equitable treatment by my supervisor. It may start as kind of a vanilla or generic complaint of harassment or unfair treatment. And as you dig deeper as an HR professional, you realize really the problem or potential problem is because that employee is saying he or she is being treated differently because of their sexuality.
Again, as we've indicated, there's no federal law that prohibits discrimination on the basis of transgender status or sexual orientation. There are state and local laws, cities that have enacted laws protecting these statuses. And so there are at least 19 states that specifically protect employees based on sexual orientation and gender identity, and 3 states that protect employees based on sexual orientation. But as there are no cases apparently under those states, those laws or ordinances, they may be extended to protect transgender status. 90 municipalities and counties protect transgender employees at this point. And New York Governor Andrew Cuomo just recently announced an executive action to protect transgender people from discrimination and harassment in housing, jobs, and public accommodation. And Charlie, I expect, to be quite frank, that trend to continue. I expect that if Congress doesn't pass a law, I would expect that cities and municipalities and perhaps even states to themselves enact such laws. Oklahoma does not currently address sexual orientation discrimination or gender stereotyping, but as we're going to discuss, the EEOC has taken the position based on current law and Supreme Court cases that such discrimination is prohibited. So an Oklahoma court could make such a ruling, and then it would be the law in Oklahoma.
Well, and Roberta, you pointed out that we do have a number of states and a number of towns and counties that recognize protection for sexual orientation and gender identity. One of the ways I've become involved in this issue are employers that are multi-state in their operations. They have employees, some of their employees are located in states or cities that do have laws that prohibit discrimination based on sexual orientation or gender identity, and they have other employees in states that don't have such a protection. And those employers face the challenge of, what do I do in those sort of circumstances? How do I cover all my bases? And how do I treat all my employees the same or fairly when I find myself in different jurisdictions and different protections for gender identity or sexual orientation? So let's start with the category of sexual stereotyping, and maybe the best way to start that is really to understand what sexual stereotyping means from a human resource standpoint and from a legal standpoint. And I guess the best way to understand sexual stereotyping is sexual stereotyping are those situations in which an employer or a supervisor makes some sort of decision about an employee or some sort of employment decision, and they base that decision on whether or not that individual conforms with their view of a gender stereotype, whether that individual fits what they think a male employee is supposed to be like or act like, or a female employee is supposed to act like or be like. And the examples I run into are situations in which the accusation is someone was treated differently based upon perhaps a supervisor or an employer's belief that although they were a female employee, they didn't act feminine enough. Or if they were a male employee, they didn't get a promotion or a raise because they didn't act masculine enough or didn't act enough like a man. And I guess where I see as a practical matter these sexual stereotyping issues bubbling up in the workplace, at least initially between coworkers, is situations in which clothing is an issue, or someone's behavior, how they're acting or how they're expressing themselves. One employee feels like a coworker or another employee is not behaving or dressing or expressing themselves consistently with what they think a male or female employee should do so. And it all begins with a Supreme Court decision back in 1989, the Price-Waterhouse case. And this was really the first sexual stereotyping case I'm aware of. And this was an instance in which a female accountant with Price-Waterhouse firm, who, no question, she was bright, technically very savvy and skilled in accounting. She was a little bit difficult to get along with, but it was her turn to be considered for partner and a promotion of partner.
I thought it was interesting in this case that there was a documented performance issue. Now, you say she was difficult to get along with, but I thought that it was interesting because often in these cases what you see is somebody who's a stellar employee who one day decides to dress differently or present differently. But in the Hopkins Price-Waterhouse case, Ms. Hopkins, there was documentation that she was a difficult employee. And when it came to supervising employees, that she was perhaps overly harsh and mean. So we have a documented performance issue, which you don't typically find in these cases.
And, when they ended up denying Ms. Hopkins' promotion to partnership, if they had relied upon those performance issues you described, they probably would have been okay, don't you think?
Well, they did rely on those issues, but it was the way they described them, that she was macho, that she should style her hair differently, that she should wear more makeup, that she should perhaps wear jewelry. If they had discussed only the performance issues and discussed it in general objective terms, I think we wouldn't have this case.
I think you're exactly right. That their observations that if she had dressed more appropriately, perhaps using more makeup, more jewelry, if she had acted more feminine, she would be considered. That's really what sank them in that case, I think. Would you agree?
I think it was too. The statistics didn't help them. Were there, 650 partners at the time, and maybe 50 or less were female. So in the year she was put up for partnership, she may have been the only female put up for partnership. So they had some numbers running against them, but the Supreme Court was very critical of the way they described her. There was a psychologist that testified on her behalf, and the Pricewaterhouse objected to the use of the psychologist, and the Supreme Court said, we don't need a psychologist to show us this is sex stereotyping. She had behavioral issues, and Pricewaterhouse thought it could be cured by her wearing a lighter color of suit and a different color of lipstick. We can see that sex stereotyping without the use of a psychiatrist or psychologist.
Yeah, I mean, the thing that really was the problem here was, instead of, as Roberta says, emphasizing her work performance issues, how she was interacting with other accountants or how she was interacting with clients, they really honed in on whether or not she fit their idea of a feminine or female accountant. So that Pricewaterhouse is kind of the new line of cases that start, but it is followed about 9 years later by the On-Cale case. And On-Cale case is really the next step, to my mind, that follows after Pricewaterhouse. Pricewaterhouse says, look, if you're going to make employment decisions, in the case of that promotion of partnership, based on whether or not one of your employees fits your perception or your stereotype of their gender, that's sex discrimination. Well, On-Cale involved essentially an all-male offshore drilling crew. And one of the members of the crew was viewed by his coworkers as not sufficiently masculine, and by virtue of that became the brunt of some very extensive derision, harassment, some groping, some sexual innuendo, and it all focused on the idea that his coworkers, his male coworkers, felt like he was not sufficiently masculine enough to be a part of their crew. And the On-Cale case, I don't think it's that far of a reach after Pricewaterhouse says, look, same-sex harassment in this particular case is also prohibited by Title VII because it is focusing on his gender and whether or not he fits everyone's perceptions or assumptions of how a male offshore crew member should act.
The conservative Justice Scalia noted in the majority opinion, while same-sex harassment was not the principal evil Congress was concerned with when it enacted Title VII, statutory prohibitions often go beyond the principal evil they were passed to combat to cover reasonably comparable evils. Title VII prohibits discrimination because of sex. So you have a very conservative Supreme Court justice saying, this is just wrong. When you're treating someone differently because they don't conform to what you think a person should be like of that particular gender, that's discrimination because of sex. And given those two cases, you can see how Title VII got extended.
Even without a change, as you point out, to its statutory language as we sit here today. Now, we talked about the fact that the Pricewaterhouse case recognized sexual stereotyping as unlawful sexual discrimination, and the On-Cale case said, hey, same-sex harassment falls in the same category in terms of being violative of Title VII. We mentioned at the outset that one of the targets of the EEOC strategic plan has been sexual orientation, transgender status in the employment context. So let's look at a few recent examples of lawsuits that have been brought by the Equal Employment Opportunity Commission in its capacity as being the agency that's charged with investigating and perhaps prosecuting unlawful discrimination in the workplace. And I just wanted to throw out 3 or 4 examples because I think they're very instructive. These are 3 or 4 cases in the last 12 months that should give us a very clear picture, regardless of what the statute says. The EEOC charged with investigating and prosecuting discrimination these send a very strong message to what that commission's plans are. And it starts with the EEOC versus Lakeland Eye Clinic, an example, again, in the last 12 months where an eye clinic's director was actually transitioning from a male to a female and informed their employer of their intention. And the clinic's reaction was, well, we hired you as a male. You are viewed in the community and among our patients as a male. So if you're going to transition to a female, you don't fit with our expectations, and you don't fit with our customers, our patients, and the community's preferences. So we're going to fire you. And in that particular case, the clinic had the pleasure of writing a $150,000 check to settle that investigation and lawsuit.
What's interesting about this case, Charlie, it's the same, it's a comparable fact pattern that you find in some of the other cases. You have an employee who's meeting expectations on the job. He'd been there several years, he was doing a good job, so it's pretty easy for the EEOC and the court and a jury to reach the conclusion that the adverse employment action, whether it's failure to promote or termination or demotion, it's pretty easy to see that it's because of the sexual stereotyping. You're not manly enough, you're not feminine enough, you don't meet our gender expectations for your gender.
And I'll tell you, what I found in looking at the case law and talking to the EEOC investigators, it's also not a defense to say, gay employees don't bother me, but our customers and clients don't want to be around gay people. That's not a defense to making a termination or employment decision either. Do you agree with that?
I agree. The EEOC is not concerned generally about coworkers and not concerned about the public. Now, bad behavior can always be disciplined. We're not talking about that. But in these cases, there seems to be a pattern of employee who's meeting expectations, has no disciplinary record, has not been written up for any poor performance. It's just that they've decided to transition to the opposite sex.
And that the Bow Brothers Construction Company, which we have listed next, falls right in the category you described. You have got an all-male construction crew, and they had one of their members who was viewed by his coworkers as lacking in masculinity, not male enough, and he was subjected to a continual barrage of harassment, derisive comments. And in this particular case, the supervisor at trial made no bones about participating and permitting such treatment. And there was little difficulty with that jury finding, that was a form of sexual harassment. He was being harassed and ridiculed because he was viewed as acting inconsistent with his sex and their expectations, and a $451,000 verdict followed.
Isn't this the case, or is this the case? I think it is, where the supervisor admitted that he exposed himself to the employee. So exactly. You have a particularly egregious situation, not the sort of fact pattern you ever want to have to deal with as an HR professional or as an employer.
Yeah. Supervisors exposing themselves to subordinates, never a good idea in work. Any context, okay? Barrett versus Pennsylvania Steel, the last example I'm going to give before we transition into your sexual orientation session, but I thought the Barrett Pennsylvania Steel case, not at all surprising, but gave us another example of where the EEOC and the courts are trending, even in the absence of any express statutory change. That was a situation in which, again, you had a male employee in the steel factory, fabricating outfit, who was the punching bag for mistreatment, for harassment, because he didn't fit what his coworkers thought the male stereotype really required. When he went to HR for protection and for assistance, HR was not very proactive, didn't take the appropriate steps to put an end to that kind of unprofessional and inappropriate workplace. And in fact, in the wake of him going to HR, when his coworkers found out, the mistreatment actually escalated, and the court had very little difficulty with saying, well, this is a classic form of retaliation. You have someone going to an HR professional, seeking help, seeking to put an end to that kind of derision, and instead of putting it into it, it just escalates. And I think that's the most recent example of a recognition that sexual stereotyping is actionable under Title VII. Now, I've got Baldwin Fox listed here in our sexual stereotyping, and that's a July 16, 2015 EEOC ruling, but I think probably that's better discussed in the sexual orientation session. And Roberta, I think that's you.
It's a good segue into the sexual orientation discussion. I think what's interesting about Fox, well, first I'd like to clarify, when you have federal employees, the EEOC not only does a fact-finding process, but they get to make decisions with regard to those employees. I mean, in most private sector employment situations, the EEOC doesn't sit in a judicial capacity. They can investigate and they can file suit, but when it comes to a federal employee, they can actually rule. And so that's what they did in this case. A federal employee said he didn't receive a promotion because he was gay, and it was, I think, the first time the EEOC specifically ruled that sexual orientation discrimination is sex discrimination under Title VII. Now, you won't find very many courts that have ruled that way because, again, that's not explicitly the law under Title VII, and so you don't see courts generally ruling in that manner. What you see, in my view, is discrimination on the basis of sexual orientation being found where the employer is accused of sexual stereotyping more often than a protection for discrimination against sexual orientation. As you pointed out, Onkale sort of set the stage. That's where same-sex harassment was found to be a potential cause of action by the United States Supreme Court.
To your point, Roberta, exactly what you said is the sort of situation I run into with employers. You have a situation in which it starts with coworkers getting into a fracas, or there's some complaint, or there's some argument over someone's behavior or conduct in the context of a sexual stereotyping issue, and it may morph into that individual, unbeknownst to anyone, also may have a sexual orientation issue. And so in a lot of times it's hard to separate the two, for me.
I think you're right. I think that one thing in discussing all of these cases and discussing this topic that we cannot forget is there are a lot of gray areas here. It's not like most situations that employers have or present to us fit neatly into a package. For example, I think if you had a male employee who was gay, but he dressed in a masculine fashion, there was no he didn't talk about his personal life. There was no indication that he was gay, and the employer fired him. I think a court would probably not be as sympathetic. Whereas if you had a factual pattern where the employer had some indication that the employee was gay, that is, they asked for benefits for their husband, or they weren't transgender, but they occasionally dressed in women's clothes, or there was, some indication, and they talked about being gay, then I think they would have a better claim for sexual stereotyping. But I think each case rises and falls on its own fact pattern, and employers are usually not faced with a clean set of facts.
Yeah, one of the challenges, and again, we'll try and address this with some of our suggestions at the end for best practices. I think one of the challenges employers and HR professionals have when you're dealing with sexuality in the workplace and related issues, it is a private issue. It can be uncomfortable, and sometimes it doesn't get to your attention as that employer or as that supervisor or as that HR professional until it's actually become a problem. The grapevine may have been humming, the gossip may have been humming for weeks or months, and unfortunately, you may find yourself as that HR professional or employer a little late to the game in trying to catch up to solve the problem.
And you're right. We'll give some advice on how to not let that happen quite so quickly. Well, sexual orientation laws, we need to at least touch on this. There have been efforts to pass laws that would protect, that would prohibit discrimination on the basis of sexual orientation. And so far, none of those laws have passed. The Employment Non-Discrimination Act, and that was the law that in 2014 that just died in Congress. It's my understanding that because of the religious exemptions in that law, that equal rights groups are not excited about resurrecting it. So I don't know what will happen. There's the Equality Act that was most recently introduced, and it does propose that Title VII covers sexual orientation and transgender status. I can't remember if it was stuck in the House or the Senate, but I mean, it didn't come out. So, but it's still alive to my knowledge. It'll be interesting to see what happens. Of course, there's currently an executive order. If you are a federal contractor, that is, you do a certain level of business with the federal government, you are, pursuant to Executive Order 11246, prohibited from discriminating based on sexual orientation or gender identity. So there's a small subgroup out there of federal contractors that are currently prohibited by federal executive order from discriminating. But otherwise, there is not a law that prohibits discrimination based on sexual orientation. And Oklahoma similarly does not prohibit discrimination on the basis of sexual orientation.
And I'm going to go a little bit out on a limb. I'm going to say, regardless of who wins the presidential election and regardless of who controls Congress, in the next 2 years, I believe we're going to have a federal law passed which protects sexual orientation and transgender employees against discrimination in the workplace. And the reason I say that is I really do believe, as you pointed out at the outset, Roberta, we are seeing, number one, kind of a sea change culturally in our view of these issues. And we're already seeing through our federal courts and the federal investigative agency, the EEOC, we're seeing that trend. So I really believe, regardless of the politics involved, I think we're going to see that change in the next 24 months.
I have no idea if you're right. I probably won't remember to give you a hard time if you're wrong. But I do think that the federal agencies, the EEOC in particular, and the Department of Justice, don't seem to think that a federal law is necessary. Given those prior Supreme Court cases, you see court decisions coming down on the side of the employee. So I think that the law is going to change, whether it's by judges changing the law or by Congress enacting one. So I do agree with you to that extent.
You're not willing to take that bet, then, I take it.
Not willing to take that bet.
Okay. Well, let's move to transgender employees. And I want to start with talking about some concepts or some definitions here. And so we're all kind of on the same page. And these are four, I think, concepts we need to keep in mind. I like using the phrase gender identity. That means more to me than the term transgender, because transgender is kind of like a generic term, but gender identity really reminds me what this concept means. It means someone who biologically may be one gender, but identifies and lives as the other gender. Sex reassignment surgery, we used to call that sex change operations. Those are actual medical procedures, and they can include hormone therapy to change an individual's body so it is consistent with the gender they identify with. Transition, that's the period when an individual begins to live as a new gender. And that may be someone who is going through surgery or hormonal therapy, or someone who's simply just making a change in terms of how they present themselves at the workplace or in public. I may have been a male, but I've always felt like and identified as a female, and I may not go through the surgery or the hormonal treatment, but I may begin to dress and act and express myself as a female. That's the transition period as well. And then we have a psychiatric diagnosis, actually recognized, gender dysphoria, which is a psychiatric condition that's related to the distress and the associated potential impairment when an individual's birth gender is different from their gender identity, and there's some psychiatric fallout from that.
Is that considered a disability under the Disability Act?
It is not considered a disability, but one thing I question is whether there could be some what I'll call ripple effect in terms of conditions. For example, what if I, because of the difficulties I'm having dealing with my gender identity, what if I become clinically depressed? I think an employer would be hard pressed to take the position that wouldn't fall as a disability under the ADA. So, one of the things we're going to suggest is I don't get hung up with whether or not this is technically a disability, because I think our recommendation is going to be there's a lot of value to treating as that such, or at least using the same approach. The Congress has addressed or introduced the Equality Act, which does recognize transgender status as protected if it were ever passed. That's pending. But again, as you point out, Roberta, regardless of what the statutes say right now, what we are seeing is we're seeing courts and we're seeing the EEOC. And just last December, we saw the Department of Justice take the position that Title VII does in fact protect transgender, sexual orientation, and sexual stereotyping, and prohibits discrimination on those bases, regardless of what the statutes say. So,
and that's an Oklahoma case.
Correct. The December 2014 case actually involves southeastern state down in Durant, or as the locals say, Durant. And that was an instance in which we had a professor at the State University Southeastern who originally, when joining the faculty, presented as a man, but during her tenure had a gender identity issue, always identified as a female, began to present herself as a woman, although originally appearing as a man as part of the faculty. No question, to your point, this was a classic case, skilled, successful, viewed very favorably in terms of her teaching skills. Her own faculty members recommended her for tenure based on her skills and her performance. However, the administration denied that, even despite the faculty's recommendations. And at that point, the Department of Justice stepped in, filed the lawsuit here in Oklahoma City, and it said, look, this amounts to discrimination based on gender identity and gender transition, and the idea that she or he does not conform with the stereotype we're looking for here in Durant. And as far as the Department of Justice is concerned, that is a violation of Title VII and sex discrimination.
One thing we're going to talk about later, but restroom use was a big issue in that case. She was relegated, the professor was relegated to one restroom, as she alleges in her complaint, one restroom in the building where her office was located. And she often had to travel to other buildings to teach classes and couldn't always make it back to the one restroom. It was a handicap restroom, which she was designated to use. And one of her other concerns, she said in her complaint, was that she would sometimes come out of the restroom and there would be handicapped people waiting to use it. And that bothered her too. So we'll talk about why designating one particular restroom doesn't work.
Well, and I think sometimes there's a tendency for us to think, these issues about sexual orientation and transgender employees, that's not something we really deal with in Oklahoma. That's something you hear about in California, that you hear about that in New York. And I just want to point out that these concepts have no geographic limitation. And this case brought by the Department of Justice against Southeastern State is right here in Oklahoma. And so it's not something we should be surprised by. It's also not something that I think Oklahoma employers should hide their head in the sand. We want to cultivate and maintain a workplace that is professional and appropriate, and we don't want to wait until problems arise. We want to be proactive in that regard. Again, a few court decisions and EEOC actions, because I just want to point these out because I think they do, again, illustrate where our society is going, where the EEOC is going with its investigation efforts, and where the courts are going. And
they also show us what we should and shouldn't do. It may not be the law of the particular jurisdiction that a person's in, but it does show the court trends.
Absolutely. Broussard was a situation in which we had a biologically a female employee who identified as a male, and a male manager trainee for the First Tower Loan Company. And when the employer said, look, you're not a male, you're a female, and I expect you to dress and act like a female, he refused and was fired for that refusal. And that triggered a lawsuit. The Harris Funeral Homes case.
I was going to say one thing
Yeah,
about
sure.
Broussard. The interesting thing about that case is he showed up as a male. They had no idea that he was a female. I mean, he presented as a male and did a good job, and they somehow needed his driver's license for something. I can't remember the facts, and that was the first time they saw that he was biologically a female. Typically in these cases, the fact pattern is more someone's presenting or is one gender biologically and wants to begin presenting as another. So there's a big upheaval. In this case, things were going well, it sounded like. They had no idea.
Yeah, and the transgender situations I'm familiar with, some of them happen as you just described, and as in this first tower loan case, and you discover the person you thought all along was one gender is in fact biologically a different gender when you have that driver's license, or they confide in a coworker and that's brought to your attention. So you may discover it, you may just stumble upon it. That's one of the reasons I think it's important. Sometimes these come out of left field and you got to be ready for them. The Harris Funeral Homes case, that was another case that kind of followed the iClinic case in that we had an employer who was very concerned about how the community or how their patrons would react. Had a funeral director, 7 years, great performance, very satisfactory, well respected in the industry, well respected in the community, and he confided in his employer that he'd always considered and identified as a female and that he intended to transition from male to female, and put his employer on notice that he would begin dressing and appearing and acting as a female at the funeral home. And the funeral home said, I'm sorry, despite your good works for these last 7 years, that would be a shock to our system. It'd be a shock to our coworkers. It'd be a shock to the community. So we're terminating your employment.
One thing that I thought was interesting in that case, in defense of the case, the lawyers representing the funeral home asked for information about the current sex organs of Harris, whether Harris had ever fathered children, and whether the employee had ever had surgery.
Yeah, well, and what does that have to do with whether or not he or she was a good funeral director? Absolutely
Well, it doesn't,
nothing.
and the court denied the request for that information, saying that it was, in a gender stereotyping case, that information had no place.
And that also gives you a good idea, again, where the courts are coming from. Last two cases, again, to give us some markers on where we're headed in terms of the court's thinking in the EEOC. And the trucking company case, the Sage Corp, is along the lines that you talked about earlier, kind of the discovery. In this particular case, Sage Trucking had a truck instructor they were very pleased with that believed and understood Mr. Brandon was a male. Later discover he was transitioning from being biologically a female and reduced his hours. Again, found to be unlawful. And then the last example involves a Cincinnati cop, Officer Barnes, who essentially tried to keep his transgender status secret. And the way he did that was, while at work and on duty as a police officer, he presented and lived as a male. But then, while off duty, not in uniform, acted, behaved, and presented as a female. When that came to light by his superiors, he was immediately demoted, and that triggered, not surprisingly, a Title VII claim. Now, I've run into, I guess, most recently, a lot of the questions I get involving sexual orientation or transgender employee status involve restrooms. Has that been your experience as well, Roberta?
Well, I think that you see in most of the cases where we're able to get to the facts, and even cases that current clients have asked about do involve restroom use. It seems to be the biggest issue here. And OSHA in June of 2015 decided to issue a guidance. And I have clients ask why OSHA had any interest in transgender employees and restroom use. And OSHA defended their guidance, which is a guidance, not the law, by saying it's our role to make sure that employees have a safe place to work. And employees who are hesitant to use the restroom or put off using the restroom or fearful, that can result in illness. It can result in disease and discomfort. And so OSHA very easily defended its position in issuing a guidance on restroom use. The nutshell version of the OSHA restroom guidance is you can't force someone to use a certain restroom in two ways. If a male transitioning to female wants to use the female restroom, they can, according to OSHA. And you can't do what the university did. You can't segregate that person to a handicap or a standalone restroom. They can have the option of using the standalone restroom. You just can't require that. So basically, the guidance says you have to let an employee use the restroom consistent with the gender with which they identify. So if they identify as a female, they can use the female restroom. I have one client that is fighting a lawsuit where a transgender female is using the restroom, but she's standing up to go to the restroom. And this is causing great consternation with the female employees who share the restroom. And the female employees complained and argued that they were being harassed and subject to a hostile work environment. And that claim by the employees, I don't believe will be successful. I think the EEOC and OSHA and other federal agencies will side with the transgender employee using the restroom consistent with the gender with which they identify. So I think that as a business, if you want to make a decision to prohibit restroom use, that's a business decision that you can make. But I think at the end of the day, you won't be successful.
You mentioned that the guidance says that if I'm a transgender employee, I get to use, for example, if I'm transitioning to female and identify with female gender, I get to use the female restroom. They gave a couple of other options, I guess. They gave an option of a unisex restroom and increasing restroom privacy. What are you seeing employers consider as options in terms of increasing restroom privacy when trying to address the issue of transgender employees and restroom use?
Well, I think if you have the issue, if you're building a building or if you're remodeling a building, you should consider changing the restrooms to increase privacy. And what that could mean is causing the door and the sides to go all the way to the floor, so you can't easily see who's in the stall next to you. It could also include that gap in the door, putting some sort of privacy panel in the gap in the door, all measures to make it more difficult for anyone to see into an individual stall. If I were building a building or remodeling a building, I would absolutely do that. And if I had employees that were complaining, female employees who were complaining about using the restroom with a transgender female or vice versa, then I think I would consider retrofitting if that were available to me, or talking to my landlord about the cost of retrofitting restrooms. I think it's probably cheaper than the cost of a lawsuit.
Right, and it's not, as we learned in the Durant case, it's not an option to say, well, I've got a special restroom for you.
It's not an option.
Okay.
According to the government, it's not an option.
What about FMLA issues? What are your thoughts on whether or how the FMLA comes into play with transgender employees, Roberta?
Well, I think there are several ways that it could come into play. You mentioned earlier someone going through depression. Any serious medical condition that a doctor is willing to certify is in fact a serious medical condition qualifies for family medical leave. And so I think that it could come up here from the more serious end of a sex reassignment surgery. I think having surgeries generally in the recovery period is generally considered a serious medical condition. I think that, hormonal treatment with side effects, if there's side effects that prevent me from coming to work, I think that there's probably a pretty good chance that a doctor would say it's a serious medical condition and I would qualify for the leave. I think that probably most companies don't have health insurance coverage for this. I don't think that would be a reason to deny family medical leave just because there's no health insurance coverage for this. What do you think?
Yeah, the health insurance coverage issue I've seen go both ways. I think there are two variables on the health insurance issue that an employer and HR professional might run into. Number one, it may be a function of how your coverage is described, what procedures are covered, and also, I guess I would advocate when you're interpreting health insurance issues vis-a-vis a procedure or treatment related to a transgender employee, I'd focus on what the treatment is, and I mean medically the procedure, and not why they're getting the treatment. I think that's the safest path to follow. So now I think we're at the point, Roberta, where we've given an overview of what the law is and where you and I think the cases are going. Now we get to the practical standpoint of what do we recommend in terms of best practices for employers when faced with sexual stereotyping, sexual orientation, or transgender employee issues at their workplace.
I gave a talk on this recently, as did you, and I think that my first recommendation was that companies act soon to change their policies. Again, it's not required under Oklahoma law or federal law that these be protected categories. But however we end up there, I think that they will be protected categories. And I think that it's the smart move to change your policies and to protect and to prohibit discrimination on the basis of transgender sexual orientation or sexual stereotyping.
I'll give you another reason why I agree with you, and that is not only do the laws, and I think the trend we're seeing from the federal government and the investigative agencies, not only are they pointing that way, but I think, again, the societal changes we're experiencing, I think our workforce expects us, as they should, to be the grown-up in the room when it comes to these kind of issues. They expect us, as they should, to cultivate and maintain an inclusive, professional workplace that really focuses on whether I'm doing my job as an employee and not so much what my sexual orientation or preference is. So I think the other reason your recommendation, kind of being proactive in policies, makes sense is I think our workforce expects us to behave in that fashion. Am I off there, do you think?
Well, I think most companies just want good employees who will do good work. I think most managers and most HR professionals are bogged down by all of the distractions that come into play when people don't respect one another, when employees can't get along, when there are issues. I think that most companies do want to respect the individuality of their employees, and they care more about getting the job done than they do the personal life of their employees.
Well, so let's tick off a couple of points here. One thing I think we sometimes face as an employer, on the one hand, we want to be proactive. On the other hand, we want to respect employees' privacy and the confidentiality of their medical condition, their emotional or psychological condition, or just their private lives. So what suggestions do you have for employers when it becomes an issue? My sexual orientation becomes an issue, and it may be because I bring it to your attention, or it may be because coworkers. How do you recommend HR professionals deal with that confidentiality and that privacy issue in the context of human sexuality?
Well, I think the first step is to have a workplace where an open door policy is recognized. You want your employees to bring issues to you. If you don't hear about the issues as managers, supervisors, and HR professionals, you can't deal with the issue. And so first and foremost, you want to have a climate where employees feel comfortable coming forward. When it comes to an employee who is transgender or who is gay, I think that ideally what you would want is to sit down with that employee and say, how can we make this work? How do you see this? How do you see your transition happening? What can we do for you? And you then at least find out what they're asking of you as the employer. You may or may not be able to do it, but at least you've started the dialogue. They've made their request to you about what they want. It may be, I'm a transgender female, so I look like a male today, but within the next week, I want to start wearing women's clothes. I want my name to be changed. I want my name to be changed in the employment records. I want to be able to use the women's restroom. I think that you need to have an open conversation with them about dress code. I mean, that transgender female wouldn't be permitted to wear things that your current female employees couldn't wear. And if your work environment that requires personal protective equipment of any kind, you'd want to have say you're in a plant, you would want to have a conversation about how the employee is going to continue to comply with requirements regarding personal protective equipment. So you just want to start a lengthy dialogue, and you may not say yes to everything, but you at least want to have the conversation. You want them to know that you're interested. And then I think as part of that conversation, you also want to talk to them about what can we say to other employees? When do you want us to have conversations with other employees? And then I think you have to begin training and dialogue with the other employees so that they can be more accepting of employees who want to make these sorts of changes.
I think your idea about how critical at the front end the communication with that employee who is having the challenge is really important. And sometimes you may, as an HR professional, get your hand forced a little bit on confidentiality. I mean, at one point, if the workplace is abuzz and there are some problems, I mean, there are some people that are acting out, either the transitioning employee, the example we gave, or maybe his or her coworkers, we don't have the luxury of not acting. And so, I think the idea you give of asking the employee what they want or what they have in mind to meeting these challenges in terms of when other people get brought in is great, but we have to keep flexible enough to act when appropriate. One thing I think that's important that people need to keep in mind is sexual orientation or sexual stereotyping or transgender status. We're going to be tolerant, we're going to be inclusive in that regard, but bad behavior or improper behavior, whether it's that transitioning employee or whether it's coworkers, is not going to be tolerated, and we're going to put an end to that. Anything that is unprofessional, inappropriate, regardless of who the perpetrator is, we're going to put a stop to.
You do. You want to establish those boundaries and those guidelines up front. I think people are less likely to break the rules if they understand the rules. And again, it's truly important that everyone understand that bad behavior won't be tolerated. The fact that you're trying to work with these people doesn't mean that they get a free pass to do things that other employees wouldn't be permitted to do.
Yeah. It seems like to me, at least at this juncture, most of the issues I've become involved in are at a point in which the coworkers are the problem. They're giving the individual, based on sexual stereotyping or orientation, they're giving them a hard time or a difficult time, and that's what's brought it to the HR professional's attention.
I would agree. Those are the situations that I think most lawyers in McAfee's labor and employment group would say they've been faced with. The coworkers are upset and behaving badly. And I think that that's all the more reason that savvy employers will begin to educate employees, perhaps before they even have the issue.
Well, and we gave some examples here. Interestingly enough, Chevron and Ernst & Young, and again, this goes to your point that regardless of what the current state of the law is, a lot of employers are saying, you know what, I'm going to take my existing equal employment, non-discrimination, and harassment policies, and I may be in a state where there's no protection with regard to transgender and gay employees. But you know what? I'm going to revise my policies because I think it's the right thing to do. I think it is consistent with an inclusive and professional workplace. And maybe I'm in multiple states where some are covered and some not. I'm going to go ahead and unilaterally revise my existing EEO and harassment policies to protect transgender and gay employees. And that's what Chevron and Ernst & Young has done. And I guess that's kind of where I'm coming to. I think that's the trend in the law. I think that's the kind of workplace most of us think makes sense. And it's the most defensible, I think.
I would agree. I think it's clear there's some things not to do. And if you look at the cases, you can see that some employers, automatically require psychological testing of anyone who says that they're transgender or going to be transitioning, and I would never recommend that. Now, sometimes I know we've recommended that sort of thing for employees who have had extreme and outrageous behavior, but while there may be some employers that personally consider this extreme and outrageous behavior, it's not where the courts are headed now.
Right. We're still focused on performance and behavior in the workplace and really judging everybody the same way when it comes to those issues. I think the last piece here in terms of suggestions for our listeners, this is not something that's going to go away. It's not something that's going to change. It's not something that we're immune to here in Oklahoma. So again, I think consistent with our recommendation to consider updating or revising your current policies, don't forget the part of sensitizing and training your HR professionals and supervisors on what to do when they get faced with that transgender or sexual orientation question. You don't want them to get caught flat-footed. I think that's a danger.
I agree. There's a danger of giving the wrong response if you haven't prepared the right response. And although the law today has not changed, let's not forget there is that case pending in Oklahoma, and a ruling in that case would be the law in Oklahoma, and it could change everything.
Brad, I want to thank everybody for participating with Roberta and I in today's webinar. We hope we gave you a good view of where we think the law is headed and also some practical suggestions on how to be ahead of the curve on some of those issues. Thank you for participating.